Great harm was done, wrote Ontario Superior Court Justice Edward Belobaba in a decision handed down this week in a class action lawsuit resulting from the so-called 60s scoop. The case pursued damages for nearly 2 decades of government action that removed Indigenous children from their families and communities and placed them in non-Indigenous homes of foster care in Ontario from the mid-1960s to the mid-1980s. The court sided with the plaintiffs this week, and that ruling brings to our studio Marcia Brown Martel, Chief, Beaver House First Nation, and the lead plaintiff in the suit, and lawyer Jeffrey Wilson of Wilson Kristen LLP. Welcome to you both. What a week. Before we talk about the judgment, I wanted to show you a clip of your reaction to the ruling.
My mother gave me the name of Sally Susan Matthias, but that name is no more. And the 60 scoop has come to this day, this great plateau. It is a great day in Canada when Canada's judicial system chooses to say that our children are so valuable and sacred and precious that we will protect them by law. What a day this is. Yes.
Chief Martel, you've had a few days for the ruling to sink in. What does the judgment mean to you personally?
That the work that has been done, very focused work that has been done over these years, the many, many people who have come together to say, we want Canada to be a better place. We want the children within our countries. We want our children in the world. We want our children within Canada to be protected by law, not by an interpretation of an understanding, not by interpretation, but by the very law within Canada that children, the most vulnerable in our communities, are protected. Huge.
Jeffrey, what prompted the government to take these kids out of their homes and communities in the first place?
Well, that's a pretty loaded question. The government may say that we did it because we thought it was in the best interests of the child, that we thought that human beings can be raised and raised to their benefit, even if they are deprived of their natural being, of their connections to their family, their extended family, or their communities. Some others might say that it was a form of assimilation. Some go so far, although I'm not sure go so far is the proper term, as to describe it as a form of cultural genocide, in the sense that the government, consciously or unconsciously, wanted to get rid of the Indian problem, or wanted to take the, quote, savage out of the child, end of quote. And the way to do that was by placing them in non-Aboriginal homes to be raised as white folk, and by the word white I mean as non-Aboriginals. So there are many reasons why the government may have done this or permitted it to occur, but it's not something that just belongs to the government, because the government is the people of Canada.
Who else does it belong to?
Well, it belongs to the people of Canada. So the people of Canada today, and why the decision hopefully is of significance, is because the people of Canada should engage in a process of healing. And I'm not just referring to the healing that First Nations survivors have to do. I'm talking about the healing that non-Aboriginals have to do, in the sense of we were complicitous in permitting this to happen, or the many loving parents who took care of First Nation children, those who adopted them or were long-term parents. There's a healing there too, because they were deprived of the opportunity, not just the children, but they too, in giving of love to the children, were deprived of the opportunity of enabling the child to benefit from their love and also maintain a sense of belonging and connectedness to the home that that child has to their community. You can be a First Nation child and know your First Nation child and be loved by somebody who's not First Nation. That is, those are reconcilable concepts. But, and what this lawsuit was about was, why did Canada permit a situation where you can't do that? If you go into a non-First Nation home, then the effect of that is you lose that
Your
identity.
Indigenous heritage. Marcia, Chick Martel, you were taken from your home when you were 4,
Yes.
and you were adopted at 9. Did your life change significantly after you were adopted?
Oh, definitely.
How?
There was no one to speak my language with. My Algonquin language was my first language. It's the one I understood best in. It was it was my language. I could only speak with it with so many people, and those people were not with me anymore. They were somewhere else. I didn't know where they were, but they were somewhere else. They weren't with me. And now I was with people who couldn't communicate with me in the way that I thought, in the way that I think, and in the way that I learn. They didn't understand those things.
It must have been very scary.
It was terrifying. But I don't know how you can become accustomed to being terrified. You just deal with it. Then the abuse comes because there is no accountability. You know, the people that dropped me off weren't accountable anymore. You know, who was going to tell them of the terrible things that happened to me? No, not me. I was young. I'd already learned that I don't get listened to, so I don't talk. That was a choice. But you know, in places like my adopted family, it was their good intention to bring me in, loving little girl, raise this loving little girl. I didn't speak their language. I didn't think in a way that they thought. I didn't think of regular things in the same way. I didn't think of spiritual things in the same way because I wasn't taught that. I was taught a different way of doing it. Same thing, just a different way. And how could it do anything but fail? Nobody brought us together to understand the challenges and the differences and those kind of things. It couldn't do anything but fail. Some were very fortunate that it didn't. But where I was, loving, caring people took me in. And when life got hard and people want to be loving parents, and that isn't working out well because we have differences in so many ways.
You don't know a way of communicating.
I don't know how to communicate to them, and you know what? They don't speak my mother tongue. They can't communicate to me either. It must be frustrating. I'm a parent.
Part of the press conference that we had after the ruling came out, you said that when you were that age, you were vulnerable because you didn't have a voice, but now you have a voice. And before we started taping, I was asking about your relationship with Jeffrey, and you said it took you a while to find someone to help you to get this case out. I wanted to know more about your relationship, Jeffrey. How did you two connect, and how long have you been working towards this goal?
I think we connected. I think the great day happened up in Kirkland Lake or somewhere about 11 years ago. And
Yes.
I was working, I'm not a class action lawyer, although this is a class action case. I was doing child protection work.
So I take on this case then?
Because you saw repeatedly in my work the problem of dysfunction owing to the fact that people have no sense of belonging. They have no sense of connection. They have no identity. And you see that dysfunction playing itself out in their lives and in their roles as parents to their own children. And you see the same repeated patterns. And then you say to yourself, how does this happen? Why does this happen? Why do we pretend, why do we continue to hold to the legal fiction that if I am an adopting parent, I own you, and I own you exclusive of your other very important part of your life, which is your origins, your nature. Why do we do that? And so then a group of people, First Nations primarily, we met, and then I'm not sure how, it was a gift. It was a gift. I don't know how I actually ran into Marcia, and then we met, and then Marcia recounted to me her life and the fact that she was registered. You know that from the claim that the person with whom I've had the great pleasure and honor to represent, according to the records of the Federal Indian Affairs Department, was deceased. She was registered as deceased.
I came back into Canada and sought my identity in a way, some paperwork that I could have cards and go to the bank and go to school and do all of those things with. And I found out I didn't exist. I felt alone before.
Now you really felt alone.
I felt, and I was alone. It wasn't that it was just a feeling. I was alone. If I had died any time before I was 18, I would have been in, like many others, in a graveyard somewhere. Somewhere. Some municipality would have buried me somewhere with no name. But that's not what happened.
Yeah.
And then Vicky came along.
Who's Vicky?
Vicky was the executive director of Kunawanamano, and she came and presented about, there's something that I hear fairly often, and I heard it today as well, not in criticism, but people say the so-called 60 scoop. Within the First Nations, when we speak of this time, when we speak of not the so-called resident, we don't say that. We say, because it's so real to us, it is the 60 scoop. It is because the millennium scoop, which is happening now, we don't say that it may be so-called. It is. So we say it happened. It's part of our history. Whether we acknowledge it or not, it's part of Canadian history. 60 scoop is part of Canadian history. The millennium scoop, which is happening now, same thing, different era, different day, different tactics.
And Jeffrey, you've been working on this for 11 years, 8 years in court. Were you surprised by any of the legal arguments that made up the government case?
On certain days I was, and on certain days I wasn't. It's a little bit mind-boggling, confusing, disappointing, bewildering to hear a government, whether it's the conservative government or the liberal government, and both argued the same thing, that what took place should be condoned or should not form the basis of any accountability before the courts because, after all, we did it in the best interests of the child. So that's a little provocative for me, and I think for many other people, because you would then argue that it was also in the best interests to do what we did in respect of the many survivors of the residential schools. And not more importantly, and also, and somewhat fearfully, if people believe that what they did then was in the best interest of the child, then of course it could happen again. Because we could do it again, saying it's in the best interest of the child in respect of Indigenous children or any people's children. And that is what the case may signify, that there's a limit to what we can do in the best interest of a child. There are certain limitations, right? And government has to be held accountable.
What impact will this week's ruling have on the efforts of the Minister of Indigenous and Northern Affairs, Carolyn Bennett, to negotiate a settlement between the federal government and the survivors of the 60s scoop?
Well, the Honourable Minister has indicated that the government absolutely, the word absolutely was her word, has no intention of appealing. And then the next step is, if the government has no intention of appealing and accepts the ruling, then liability has been shown in respect of the conduct of Canada as a defendant. And the next step is to move on to discuss damages. Damages are then broken into two branches. Damages in respect of individual claimants receiving monetary compensation, and then aggregate damages is another way of looking at it, or providing for funds to create a healing foundation and more creative ways of ensuring that this doesn't happen again. And the lawsuit was commenced not solely for the purpose of putting money in people's pockets, and I don't say that in a harsh way, but it was my client, who's sitting to my right, our concern and her concern was, as a result of this case, if we are successful, can we make changes in society systemically to ensure this will never happen again? And so we invite and we want to sit down with the minister to discuss out-of-court resolution that perhaps provides for a healing foundation for restorative justice and some kind of a consumer watchdog foundation within the First Nations community that monitors legislation as it affects children, all children, but especially Indigenous children, to ensure that this doesn't happen.
Well, I wanted to read take a look at some numbers. Data from the National Household Survey suggests that of the approximately 30,000 children in care in Canada in 2011, 14,225 were Aboriginal. Overall, 4% of the Aboriginal children were in care compared to 0.3% of non-Aboriginal children, or 15,345 children. And here's a portion of what the judge in this case wrote in his decision. The uncontroverted evidence of the plaintiff's experts is that the loss of their Aboriginal identity left the children fundamentally disoriented with a reduced ability to lead healthy and fulfilling lives. The loss of Aboriginal identity resulted in psychiatric disorders, substance abuse, unemployment, violence, and numerous suicides. Jeffrey, how do you think this week's decision will impact Indigenous children who are currently in care in Ontario?
The decision will have a ripple effect, as jurisprudence may often does, and it will make clear, I think, or I hope, that we can no longer pretend that we can take care of children and deny them a connection to their family, extended family, and communities. I think that will be the one important result of this decision. It comes from the civil action, but the civil action and the observation that you've recited will say that government can be held accountable if it fails to ensure that we belong. We all belong to the tradition, customs, and languages where we were born, which is our family.
And Marcia, what role do you hope to play in the continuation of this story now that we have this ruling?
Myself with over 600 others, I believe part of our role is to ensure that the accountability, that when organizations come to First Nations and speak of their involvement with the Indigenous people of this land, that there will be an accountability to when that mandated check marking box of we did this, and we did this, and one of those things being we involved the Indigenous people in the inclusion of our programming, in the development of program, things like that. That it will not be some fine artist's work on a wall, that it'll actually be a practical piece of, we sat down with people and we talked best how to involve and how to address the people within the community and how it would be best addressed for our people to come out and become a group of people working together, not only within the First Nations, but within the urban community as well.
But don't think for a moment that this ruling in and of itself is the reason for the data that you observed. I mean, what this ruling should inspire is for Canadians, again, to examine why there are these problems and their contribution or complicity in permitting these problems to exist. I mean, belonging is important. It's very important. But so are other factors, poverty, right? Awful conditions, housing, right? Lack of appropriate funding for social services on the reserve that are in any way equal to those social services for non-Aboriginal children or Aboriginal children off the reserve. So there's a host of problems in respect of which repeated governments have not addressed. This government as well. And so Canadians, I apologized on August 23rd in court at the end of my submission as a Canadian to my client and to my constituents, because when you read this and when you become immersed in it as a white privileged male, you have to look in the mirror and you have to say, I'm sorry. I apologize as a lawyer, and I apologize as a Canadian for the fact and nature of the harm that has been experienced by our Indigenous people.
Well, congratulations, and thank you for continuing the fight.
Thank you.
Thank you very much, Jeffrey and Chief Martel. Safe travels home.
Yes.
Thank you.
Miigwech.
Help TVO create a better world through the power of learning. Visit TVO.org and make a tax-deductible donation today.